Hi, I'm Lori Nelson. I'm an attorney at Jones Waldo, and I practice in the area of family law. What I'd like to talk about are the new rules of civil procedure as they relate specifically to family law, as well as some other rules that aren't specifically family law but impact the family law area. First of all is Rule 101. This talks about filing motions. Motions must be filed in writing. They have to be accompanied by an affidavit, and you can also have a memorandum in support. You have to serve opposing counsel within 14 days of the hearing. This rule and all the deadlines according to this rule are all triggered by the hearing date. So if you don't get a hearing date, none of the other deadlines are implicated. So you have to serve opposing counsel 14 days before the hearing date. When you file your motion, you get your initial hearing at the same time. It's easy to track the deadlines. If the motion is filed more than 90 days after the last most relevant pleading, you cannot serve counsel and you have to serve the party themselves. The responding party then has 5 business days within which to file their responsive pleading, and then the moving party can file a reply brief 3 business days before the hearing. If the motion includes a request for alimony, you have to include income verification and a financial declaration, which is signed and notarized. This also applies to responses. If you are filing a responsive pleading to someone's request for alimony, you also have to file income verification and a signed and notarized financial declaration. Also, if a motion requests child support, not only do you have to have the income verification and the financial declaration, you also have to have a child support worksheet. The rule also requires that if the motion requests certain relief for which verification is required and those attachments are not included on the motion, the responding party may object to the motion as being defective. That defect can be cured 2 business days before the hearing. Courtesy copies must be filed along with filing the original motion, and they must be filed with the commissioner who is hearing the motion. The courtesy copy must specify the name of the commissioner and the date and time of the hearing to ensure that it gets to the proper court. If a party files a late filing, either responsive or reply, the commissioner may do one of several things. The commissioner may hold the hearing, allow the other party time to respond, continue the hearing to allow time for written response, reject the filing in its entirety, impose costs and fees, or other sanctions as the commissioner deems appropriate. It's important to know that if you want affirmative relief and you are the responding party, merely opposing the motion is not sufficient to grant affirmative relief. If you want affirmative relief, you must file a counter motion. It's also important to note, according to Rule 101, that no hearings may be held before the deadline for appearance of counsel as specified in Rule 12. Rule 101 also makes a distinction between motions for temporary orders and orders to show cause. Orders to show cause are now only to be used when a party wishes to show that there is an existing order in place which the other side has violated. The standard of proof in an order to show cause is probable cause. Rule 101 also specifies which motions will be heard by judges rather than by commissioners in those districts where commissioners sit. The motions specifically heard by judges include motions for alternate service, motion to waive the 90 days, motion to waive the divorce education class, motion for entry of a default judgment, motion for leave to withdraw if the case has already been certified for trial, and all motions in limine. Rule 101 is a new rule, and it's very important for domestic practitioners to become familiar with that rule and the deadlines involved. Another new rule that deals specifically with family law cases is Rule 102. Rule 102 is the attorney's costs and fees rule. That rule requires that either party may request fees, including expert witness fees, as well as expert retainer fees, to either prosecute or defend the action. You need an affidavit to support the factual request, and you need to specify the amount you are requesting. You may include in your affidavit of costs and fees those costs and fees that are incurred both prior to the commencement of the action, incurred during the action, or after entry of the judgment. The court has the discretion to grant motions for fees if if it finds several factors. First, if the moving party lacks the financial resources to prosecute or defend the action, if the non-moving party has the financial resources, if the costs and fees are necessary to put the parties on a level playing field, and if the amount requested is reasonable. The court may deny the request for fees if one or more of the foregoing are missing, or if it enters findings into the record specifying why it denies the request for fees. The order shall specify that the fees will be paid within 30 days of entry of the judgment, or a specific finding that delay will not create an undue hardship or prevent the requesting party the ability to prosecute or defend. The order shall also specify the amount ordered and shall provide the term of payment, whether it is in a lump sum or periodic payments. Rule 106 also applies to divorce and domestic practice, and it relates specifically to modification of divorce decrees. Rule 106 provides that all modifications of divorce are begun by a petition to modify a divorce. They cannot be initiated by motion. However, the court does have some limited authority to make temporary changes in a modification. During the pending modification, the court may order a temporary change in child support as part of a temporary modification of custody. The court may also, in modifying temporary custody, may do so to address immediate and irreparable harm or to ratify changes the parties have already themselves made, provided those changes meet the best interests of the child. Even in modification petitions on a temporary basis, the best interest of the child still is the governing standard. Furthermore, Rule 106 does not prevent the court's authority to make temporary orders pursuant to 30-3-3. There are some rules which are not specifically related to domestic law, but which are implicated in domestic practice and which domestic practitioners should become familiar. The first one is Rule 26 of the Utah Rules of Civil Procedure. That is the rule that deals with discovery and how that shall be handled. Specifically, as it relates to domestic practice, it's very helpful if domestic practitioners have on hand a ready list of initial disclosures that they would like to exchange. The list of initial disclosures that are most frequently utilized in domestic practice include a completed financial declaration, pay stubs for at least the preceding 3 months, tax returns with all schedules for the preceding 5 years, bank statements for all bank accounts, whether personal or business, checking, savings, and money market, and whether or not the party has signing authority, most recent retirement statements, business, employment, or other types of partnership agreements, statements from any brokerage houses, stock accounts, investment firms, or other savings types of accounts which a party may have, information regarding real property interests, designating ownership of that property as well as amounts owed and who, if anyone, holds the mortgage on those real property interests, credit card statements, most recent billings for monthly living expenses, and other types of debts and obligations that impact the monthly budget of either party, as well as other interests in property such as stock options, retirement accounts that are not otherwise specified through your employer, and other types of benefits which are not normally considered property but which can be considered by the divorce court, such as Sky Miles or a country club membership. Also relevant to the domestic practice is Rule 4-202 of the Utah Rules of Judicial Administration. This rule is becoming increasingly important in the domestic relations arena given the new problems everyone is having with identity theft. Many of the documents which are required to be filed in a domestic relations case contain personally identifying information. The financial declaration, in fact, asks for a social security number. All of the bank statement accounts contain account numbers. Tax returns have social security numbers. Pay stubs have your employer identification number and can have other personally identifying information. Rule 4-202 of the Rules of Judicial Administration specifically states that all domestic filings, all exhibits, all financial records, all case files, all pleadings, everything are open to the public. Therefore, domestic relations practitioners have to be very careful about the type of information they submit. Specifically, it's important to redact from all filings, all account numbers, all but the last 4 digits of a social security number, a person's birth date, and other identifying information. From the tax returns, what you should redact: the social security numbers not only of both parties but also of any children. You should redact from the W-2 the employer identification number. You should redact from the bank statements all but the last 4, 3, or 2 digits of the bank account numbers. In order to protect your client and their identity, because all of this information is public and readily accessible to the public. You should also not include driver's license numbers on any of the information you provide, except for those forms which are specifically required by the court but are held private. In order to exchange information and to adequately allow each of the parties to prosecute the case, the parties can either enter into a formal protective order regarding the information, or they can just exchange all documents privately and not submit them to the court. It's also important to note, however, that in all written pleadings where an individual specifies debts and account numbers, not to include the entire account number. It's not sufficient just to redact the information on an exhibit but then put the identical information in the pleading. It has to be redacted entirely so that account numbers are not available to the public when they access these